Paul Vallone. You are listening to 106.7 Wilmington's Big Talker. I'd like to welcome you to Guns, Politics, and Freedom, where each Sunday at 5 p.m. as part of the Sunday Night Political Power Block, we give you the ammunition to better defend your gun rights. I'd also like to thank our sponsor, Hyatt Guns, America's largest gun shop. Check them out at hyattguns.com. In case you aren't familiar with me, I direct Grassroots North Carolina, or GRNC, since 1994, our state's most effective gun rights organization. As its director, I was involved in drafting and passing our original concealed handgun law. Since then, GRNC has gone on to engineer passage of concealed handgun reciprocity, our purchase permit bypass, Castle Doctrine and Stand Your Ground, the expansion of concealed carry to state and municipal parks, restaurants, public assemblies, educational properties, and much more. Grassroots North Carolina is exactly what the name implies, a grassroots collection of volunteers from all walks of life who share a common concern that our constitutionally guaranteed freedoms are being eroded. Check us out at grnc.org. That's grnc.org. Today, we will discuss the recent Supreme Court decision on Remington versus Soto, in which the court essentially allowed the lawsuit by families of the Sandy Hook victims against Remington to continue in apparent contravention of the Protection of Lawful Commerce in Arms Act, passed by Congress in 2005 to stop what was then an onslaught of class action suits by cities, which was designed to drive most gun manufacturers out of business, or at least to force them to voluntarily adopt gun restrictions. To discuss the implications of that decision, we will have as our guest nationally renowned gun rights attorney and author David T. Hardy, whose books include I'm From the Government and I'm Here to Kill You, The True Human Cost of Official Negligence, and most recently, Mass Killings, Myth, Reality, and Solutions. We will also discuss the commonality in all of the proposed public policies of the left, namely that they are all self-destructive, not only to America as a whole, but even to the leftists themselves. But first, this just in gun rights news. ABC's host of The View, Joy Behar, recently let the cat out of the bag when she discussed former 2020 presidential hopeful Beto O'Rourke, Democrat from Texas, and said it was foolish of him to announce his plans for gun confiscation before he was elected. She advised all politicians to go after the country's guns after they've assumed office. And I quote, "They should not tell everything they're going to do. If you're going to take people's guns away, wait until you get elected, then take the guns away," she said. "Don't tell them ahead of time." Said gun writer Dean Weingarten, writing in AmmoLand.com, and I quote, "To the left, this is nothing controversial. The whole point of progressivism is the electorate is too stupid and ignorant to govern themselves. They believe the purpose of an elite is to deceive the governed through manipulation of the information they receive and controlling the narrative, so as to allow the elite to keep power and govern as they wish. The purpose of the media is to be gatekeepers of the information flow and to create the desired narratives." Remember this the next time the media or leftists tell you they support the Second Amendment and that they just want common sense gun laws. Another of Weingarten's articles on AmmoLand.com was, and I quote, "Gun control advocate shoots, kills her 3 children and herself." Yes. The piece highlights a recent multiple homicide in Texas which the media, and particularly gun control advocates, don't seem all that interested in discussing. Ashley Azeni was a mother of 3 and a vocal advocate for gun control. So imagine the surprise of her friends and family when, unhappy with her recent divorce, she killed those 3 children and herself with a gun. National gun rights figure and attorney Colin Noir branded Azeni's support for gun control as, and I quote, "complete and utter projection." He went on to point out that a large number of gun control advocates don't trust you with guns because they don't trust themselves with guns. These entitled leftists lack the discipline and self-control to own firearms. Therefore, you must lose your right to keep and bear arms. In the late 1990s, a number of cities decided to pursue what they called novel legal arguments, using mass tort litigation to sue gun manufacturers over products which were not defective and, in fact, performed exactly as intended. These cities hired lawyers that had recently secured massive judgments from the tobacco industry. In one particular insult, the city of Atlanta decided to join the fray and sue gun manufacturers in 1999, announcing their lawsuit on the opening day of the world's biggest gun industry trade show, which was in Atlanta that year, namely the Shooting, Hunting, and Outdoor Trade Show, or SHOT Show, in Atlanta. Their goal, of course, was to drive gun manufacturers out of business under the burden of defending against dozens of lawsuits, or at least to force them to accept restrictions on firearms which gun control advocates had not been able to obtain via legislation. In particular, you may recall that when Smith & Wesson was owned by a British company, Tompkins plc, they negotiated their own agreement with the Clinton administration, under which the company agreed to, among other things, not to manufacture firearms that accepted standard capacity magazines, which, by the way, would be virtually all semi-automatic handguns, not to sell firearms to dealers unless they agreed not to sell standard capacity magazines or semi-automatic firearms, and to refrain from selling to gun shows unless every seller at the gun show conducted so-called universal background checks, meaning universal gun registration. Fortunately, Smith & Wesson never had to enact those restrictions because, in response, the NRA began pushing legislation at both state and federal levels to stop the city lawsuits. Some gun rights advocates at the time, yours truly included, speculated that the NRA wanted the legislation a little too much. Noting that Bill Ruger of Ruger Firearms fame was a big contributor to the NRA Museum to be exact, they posited that the NRA was willing to give away too much to get protection for gun makers. In fact, right here in North Carolina, the NRA let the Democrats, who controlled both chambers of the legislature at the time, to merge a bill to shut down most gun shows in the state into its own gun litigation bill. I'm happy to say that my organization, Grassroots North Carolina, prevented that from happening. Similarly, the first time Congress considered the Protection of Lawful Commerce in Arms Act in 2004, the NRA allowed a variety of gun control to be hung onto the bill, including cop killer bullet restrictions that would have actually banned most common rifle ammunition, semi-auto bans, an extension of the semi-auto ban, which, by the way, you may recall, sunsetted in 2004, and a variety of other restrictions. Only when a coalition of state-level organizations, of which GRNC was a member, applied pressure to the NRA did Wayne LaPierre back away from the bill, ensuring its demise. But in a demonstration of the legislative principle that it's often better to wait until you can pass good legislation rather than passing flawed legislation, in 2005, Congress passed a clean version of the Protection of Lawful Commerce in Arms Act, effectively dooming cities' lawsuits. And so it was with dismissal of any lawsuits against manufacturers of guns that function exactly as intended until a couple of weeks ago, when the Connecticut Supreme Court reversed a lower court and allowed the lawsuit by Sandy Hook victims' families in Soto versus Bushmaster, which, by the way, is owned by Remington, to move forward. Remington filed suit in the U.S. Supreme Court, arguing that the PLCAA mooted such lawsuits, but in a surprise decision, the High Court denied the writ of certiorari to Remington and, without stating any reasons, refused to hear the case, allowing it to continue in the Connecticut courts. Some gun rights bloggers called that a betrayal by conservatives on the court. Others predicted disaster for the gun industry. In our next segment, noted gun rights attorney and author David T. Hardy will discuss what the Supreme Court decision does and doesn't mean for gun rights and the gun industry. Right now, you are listening to Guns, Politics, and Freedom on Wilmington's Big Talker, 106.7 WilmingtonBigTalker.com. After a short break, we will return with nationally renowned gun rights attorney David Hardy and the full implications of the recent Supreme Court decision. My name is Paul Vallone. You are listening to Guns, Politics, and Freedom today on Wilmington's Big Talker, 106.7 WilmingtonBigTalker.com. In an order released on November 12th, the Supreme Court denied cert, meaning they refused to consider a petition by Remington Arms to dismiss litigation by families of the victims of the 2012 Sandy Hook killings. Remington owns Bushmaster, which manufactured the AR-15 used when Adam Lanza murdered his mother, stole her rifle, and murdered 26 students and educators. The decision in Remington v. Soto effectively allows the families of the Sandy Hook victims to proceed with a lawsuit against Remington, despite the company's claims that it was protected from liability by the Protection of Lawful Commerce in Arms Act of 2005. Remington petitioned the court to reverse a March 2019 decision by the Connecticut Supreme Court, which ruled 4-3 that Remington could be sued under state law over its marketing practices, citing one of the few exemptions to the federal law. As we discussed in the last segment, the PLCAA was enacted to stop the wave of mass tort lawsuits by cities using what they claimed were novel legal theories to drive gun manufacturers out of business. Here with us today to discuss the decision is attorney and Second Amendment advocate David T. Hardy, whose most recent book is I'm from the Government and I'm Here to Kill You, The True Human Cost of Official Negligence. David is a practicing attorney in Tucson, Arizona. Prior to returning to private practice, he spent 10 years in Washington, D.C. as a career attorney in the Interior Department's Office of the Solicitor. Mr. Hardy has previously published 4 books, including my personal favorite, Michael Moore is a Big Fat Stupid White Man, which unsurprisingly made #1 on Amazon and spent 7 weeks on the New York Times bestseller list. Others of his books include The Origins and Development of the Second Amendment, The BATF's War on Civil Liberties, and This Is Not an Assault, Penetrating the Official Web of Lies regarding the Waco incident. Hardy has also published 25 law review articles, which have been twice cited by the U.S. Supreme Court and by 11 of the 13 U.S. Circuit Courts of Appeals. He has appeared on ABC Nightline, The Riley Factor, Fox News, Court TV, and on over 100 radio programs. His investigative work on the Waco tragedy was documented in the New York Times, the Houston Chronicle, and the Dallas Morning News. On the side, Mr. Hardy, David, I can't believe this one. Mr. Hardy has kept bees, set tile, shoveled in the mines, survived cancer, and, my personal favorite, been bitten by a rattlesnake. I'll pass, thank you. He does not plan to resume any of these activities in the future. David, welcome aboard to Guns, Politics, and Freedom.
I'm happy to be here. Yeah, I might have published a book since then, Mass Killings. It's available on Amazon. It shows that if there is one crime that gun control cannot hope to deal with, it's mass killings.
Awesome. And as a matter of fact, when we get done with our segment, I'm going to ask you to tell people how they can get a copy of that book.
Sure.
So, David, at issue, of course, is the Protection of Lawful Commerce in Arms Act. What exactly does the Act do?
Well, it generally exempts dealers and manufacturers from suit over the criminal use of their product. And it was enacted, I know a bit about the background. I went to the Clinton Presidential Library and dug out all their files on guns. And one was a memo that was talking about how they were going to exploit these suits against gun manufacturers. They were going to pressure the gun manufacturers to where they would have to agree to essentially a bunch of gun control, just not imposed by the government directly. Manufacturers would have to impose it, and they'd have to cut off any dealer who didn't comply. So and one of the things was no selling of AR-15s.
Okay.
And so any private dealer who sold an AR-15 would be cut off from the major gun dealers, manufacturers. Anyway, the Protection of Lawful Commerce Act essentially was meant to outlaw that type of suit.
Okay.
But it did have a few exemptions. And one of them was for if the manufacturer or dealer violated any law applicable to firearm transfers. And there's two other federal circuits which have ruled and essentially said that means if they broke the gun laws.
That sounds logical, yes. Okay.
Yeah. Well, what the Connecticut Supreme Court did was it had a state law dealing with unfair business practices. Mm-hmm. And that banned unfair competition or deception. Now, that's meant to deal with the situation where you have two businesses and the other you find your competitor is basically luring customers away from you by making false promises, that sort of thing.
Okay.
Well, the Connecticut Supreme Court had previously construed it to wider than the words and said that unfair trade practices included anything the courts found to be unethical.
Now, this is before the Soto suit, is that correct?
Yep.
Or is it? Okay. All right. Go ahead.
Yep. And so what happened in the Soto case is they said, well, the pleadings that have been filed allege that the Bushmaster's ads encouraged violence because they'd have things like a picture of a soldier and something, do your duty or be prepared, something like that. And so, okay, they claim that that encourages illegal violence. Well, that would be an unethical practice and thus illegal under the business practices law.
Okay.
So, since the Protection of Lawful Commerce Act says it doesn't prevent any lawsuit arising out of laws applicable to the firearms trade, and since this business practices law is applicable to the firearms trade, we're going to say it applies, and therefore they can sue.
But this would only could only be utilized in a state which had Connecticut's statute on deceptive marketing. Is that a correct statement?
Yep. Yep.
Do you have any idea how many states have those laws?
I suspect most of them have something like that. What they don't have is a court that says that unfair practices includes anything we as a court decide is unethical.
We do here in North Carolina have those types of courts, unfortunately. They've been throwing out our political districts thanks to Eric Holder's redistricting program, and our Supreme Court is unfortunately controlled by the left. So it could be a problem here, I guess. Continue, please.
Yeah. Well, and so that was what the Connecticut Supreme Court did, and you can appeal from the state Supreme Court to the U.S. Supreme Court, and that's what Remington did. And the Supreme Court just issued an order without explanation saying we're not taking the case.
So now
you don't have to explain those.
Now, many in the gun rights community are sort of depicting this as the end of the world, the end of gun manufacturers. I mean, first question I have is, what exactly did the Supreme Court say in refusing the case? I mean, does this actually mean anything in terms of the validity of the Protection of Lawful Commerce and Arms Act?
No, they weren't attacking its validity. They were finding a sneaky way around it. And the Supreme Court refusing cert, which is literally, certiorari, that's their form of review. The order just simply read, the writ of certiorari is denied, period.
So we don't really know why. Okay, is that a fair statement?
It could actually be different justices might have different reasons for denying it. One of the simplest ones I can think of is that this case comes out of a motion to dismiss, which is the very beginning of a lawsuit before any evidence is in. So all you're looking at is, here's the complaint, here's what they claim they can prove. Do they have a case if they can prove it? And the Supreme Court may just have figured, but why should we get involved at this early stage? Let them get some evidence in, and then let the court decide on that, and it might be worth taking.
Okay.
The problem is, for Remington, of course, that's going to be hundreds of thousands of dollars in legal expenses, and they're going to be poking around, digging out all your internal memos, see if some of you wrote a memo that could sound something like getting aggressive.
Okay. All right. Okay. I want to get back to this, and particularly what is going to happen, what's likely to happen next in the case. Right now, we're probably going to need to take a short break. Folks, we are talking about the recent lawsuit by the Soto family, victims of the Sandy Hook families of the Sandy Hook victims, and their suit against Remington. Right now, we'll take a short break. You are listening to Guns, Politics, and Freedom on Wilmington's Big Talker, 106.7, WilmingtonBigTalker.com. Please join us after the break, when we will again join our guest and attorney and Second Amendment advocate David T. Hardy. You are listening to Guns, Politics, and Freedom today on Wilmington's Big Talker, 106.7, WilmingtonBigTalker.com. Our show is sponsored by Hyatt Guns, America's largest gun shop. Check them out at HyattGuns.com. We were talking about the recent action by the Supreme Court to deny cert and refuse to listen to a petition by Remington Arms to dismiss litigations by families of the victims of the 2012 Sandy Hook killings. Remington owns Bushmaster, which manufactured the AR-15 used when Adam Lanza murdered his mother, stole her rifle, and murdered 26 students and educators. Many in the gun rights community have predicted the worst, I guess, out of this, namely the dissolution of the gun industry. But as our guest, David T. Hardy, has noted Second Amendment attorney and advocate, has noted it's actually a more narrowly crafted decision than some might have you believe. David, welcome back. Tell us why, again, that's a narrowly crafted decision. Why exactly is it perhaps not as universally applicable as some make it out to be?
Well, it's a denial of certiorari, which basically they don't explain anything. They just say, we don't want to take this one. They get about 8,000 petitions a year, and they grant about 80 of them. Okay. So this just wasn't in the top 1%. And a denial of certiorari has no precedential value. I mean, they could take the next case that comes up.
Okay.
I'm familiar with one area of constitutional law where they turned down about 10 or 12 cases, including some where attorney's fees were awarded. Then they took one and reversed everything that had gone on.
Huh, okay.
So, they could do that.
All right. So basically then, what we're looking at is they've denied cert to the case. Now it goes back to Connecticut. Okay. What happens from this point forward?
The next step would be the taking of discovery, which means undoubtedly the plaintiffs will be asking for essentially every document regarding Bushmaster advertising, how it was planned out, every memo on it, and then they'll be able to take depositions of the persons involved, everybody involved in planning their advertising, and try to see if they can trip them up and get them to say, something along the lines of, we were marketing this for aggressive purposes or something like that.
Okay.
And of course, the defendants will have a chance to take discovery too, and probably start off with written questions asking basically, where's your evidence? Because under the Connecticut Supreme Court ruling, it was only on the pleadings. They were claiming they could prove a bunch of stuff, which, if you stop to think about it, they're probably hopeless in trying to prove it. Like, for example, they allege that Adam Lanza the killer, saw Bushmaster's advertising, and based on seeing it, chose the AR-15 over the other guns he stole from the mother he'd murdered.
Mm-hmm.
How are you going to prove that? Adam Lanza is dead. We don't know what advertising he saw.
And particularly because he wasn't the purchaser of the gun, I would imagine that would be an impediment to their argument as well.
Yeah. This is very much like basically someone stole a gun from a gun owner, but we're saying he stole that gun because he saw a Bushmaster ad somewhere. How do you prove that?
Well, I guess it probably depends on what court you're in. What's the Connecticut Supreme Court look like? Do you happen to know?
I don't know.
If it's anything like our Supreme Court, we're in trouble there. But hopefully, if they do decide against us, hopefully it could actually go back to the Supreme Court after it's been decided in Connecticut, could it not?
Undoubtedly, after they've taken discovery, the defendants will move for summary judgment. That is to have it dismissed when everybody has had a chance to get all the evidence they want.
Okay.
And like I say, some of the stuff they've alleged in their pleadings is unlikely to be provable. Not just unlikely to be true, but simply, how do you prove it? So I'd say the odds are pretty good, Remington winning at that stage. So the pain in the neck, and if that doesn't succeed, then you go to trial. The pain in the neck for Remington is going to be all the months of discovery and them spying on all of your internal documents.
Yeah. So let's assume a worst-case scenario for a moment. Let's say that in Connecticut they win this case against Remington. As I say, gun rights advocates, by and large, are predicting the end of the gun industry based on this thing. Do you see it that way?
That'd be too dramatic, but I would see a big danger. Most of the gun manufacturers are located in Connecticut. They should have gotten out of that state long ago.
Well, that's their first mistake, really. Yeah, got it.
Yeah. I mean, if you're in a different state, you have diversity jurisdiction in the federal courts. So if you're sued in state court by a citizen or a company from another state, you have the power to remove it to federal district court.
Okay.
Just automatically. Just here's the pleading. We want to be tried in federal court. So you get out of the Connecticut state courts. But the problem is if you're located in Connecticut and sued in Connecticut by somebody in Connecticut, you don't have that capacity.
Well, here's a message to gun manufacturers, and it's time to leave Connecticut. Flee while you can.
Yeah. I mean, Ruger shifted out here to Arizona, so I mean, but don't stay in that state for Pete's sake.
Yeah, I know we've picked up several companies here in North Carolina. I guess Tennessee has. I guess the southeastern U.S. tends to be where a lot of gun manufacturers are moving right now, presumably for the more friendly legislative climate.
Yeah.
So what do you see overall from this suit then? I mean, what's your overall prediction on it?
The overall effect would probably be pretty limited because if you, as I say, the anti-gunners would be out looking for Connecticut crime victims. They'd have to keep them in Connecticut, so it's limited by that. The problem is they're, of course, going to go out and do a bunch of fundraising. We finally found a way around the Protection of Lawful Commerce Act. Send us your money so we can sue even more manufacturers.
Which I'm sure the media will be happy to carry that message.
Of course. We can't do it now. I mean, go back and amend the Protection of Lawful Commerce Act, but obviously, you know, with the House in Democratic hands, that ain't going to happen.
Yeah, good luck with that. Right, got it. All right, so, but it sounds to me like the dire predictions are perhaps are overblown. It is probably not the end of the gun manufacturers. The conservatives of the Supreme Court haven't sold us out. This is just one more cog in how the lawsuit moves through the courts. Would that be a fair statement?
Yeah, and maybe back at the Supremes.
Okay.
You know, if the motion for summary judgment is denied, under some conditions you can appeal that or take a different route on appeal. Okay. So it may go up then.
All right.
And frankly, even an anti-gun judge at the trial level might have some real trouble denying a motion for summary judgment. Because, I mean, like I say, if they have zero proof that the killer saw their advertising, well, sorry, case is over.
There you go, being logical again. We all know how logical the left is, right?
Yep.
Anyways, on a different note, why don't you tell us about your latest book, which was, let's see, Mass Killings, Myths, Reality, and Solutions. What prompted you to read it? And we've got about a minute and a quarter or something like that. Tell us about the book.
Well, the conclusion of the book is that what motivates mass killers is an extreme case of narcissistic personality disorder. They want to be well known, even if it's for being evil. As one guy put it, to heck with fame, I'll take infamy. And they have a symbiotic relationship with the mass media. The mass media gives them what they want, which is your picture on the cover of Time, as happened after Columbine. And they give the mass media what it wants, a sensational crime that keeps people glued to the television set and also sells advertising. Mm-hmm. So that's the big problem there, that symbiotic relationship where everyone is getting what they want.
Except the victims.
Exactly. And one of the things, what I say is I go into ways to deal with it and conclude that gun control has absolutely no hope of it. The killers pass all background checks. Mm-hmm. Waiting periods, they plan for months or years in advance. They're very careful planners. Mm-hmm. Magazine size, most of them actually carry two guns, that is.
Right.
So they're not vulnerable while they're reloading. AR-15s, they rarely use those, and when it is, it's always copycat crime. If you stop to think about it, in mass slaying, why would you want a rifle?
Okay, got it. So how can folks get a copy of this book?
Well, it's up on Amazon, and it's also linked to my website, hardybooks.net. Not .com, .net.
hardybooks.net, got it, okay.
Yeah.
All right, Mass Killings, Myths, Reality, and Solutions by David Hardy. Thank you, sir. I appreciate you enlightening us on what this court decision really means. Thank you for coming on here.
Happy to do it.
You are listening to Guns, Politics, and Freedom on Wilmington's Big Talker, 106.7, WilmingtonBigTalker.com. After a short break, we will return with still more critical information enabling you to better defend your gun rights. My name is Paul Vallone. You are listening to Guns, Politics, and Freedom today on Wilmington's Big Talker, 106.7, WilmingtonBigTalker.com. Our show is sponsored by Hyatt Guns, America's largest gun shop. Check them out at HyattGuns.com. A couple of days ago, I read a somewhat whitewashed article in North Carolina's own version of Pravda, official organ of the Communist Party, otherwise known as the Raleigh News and Observer. The piece was entitled Fact Check. ICE says North Carolina jails won't hand over dangerous inmates. You see, as the NNO correctly noted, black liberal sheriffs took over the 7 most populous counties in the state in the last election, namely Buncombe, Cumberland, Durham, Forsyth, Guilford, Mecklenburg, and Wake. Now, the NNO predictably attributes this to opposition to hardline immigration policies. Now, I'm not a big believer in coincidence, and takeover of the 7 most populous counties in the state by black liberal Democrat sheriffs would indeed be quite a coincidence. The truth, I suspect, is that dark money targeted those districts for the candidates in question. But such is the sad state of our loss of freedom of speech that we are prohibited from saying that, lest we be branded racist. But I digress. According to ICE, these sheriffs in what ICE calls non-compliant counties have refused 489 ICE detainers in 2019. That's just for the portion of the year ending August 19th. In other words, they refused to detain illegal aliens for ICE to collect. ICE devoted a lovely website just to non-compliance here in North Carolina, which included mugshots of illegal alien offenders charged with things like larceny and drug trafficking, of course, but also indecent liberties with a child, first-degree sex offense by force, and other crimes up to and including no less than 4 murderers. Now, bear in mind that these leftist sheriffs have refused ICE detainers on these criminals. And of course, the NNO went on to whitewash it, saying that four of the 489 ICE detainers refused were locked up for various reasons anyways. I'm sure you are outraged to know that the sheriffs of our 7 biggest counties are releasing illegal alien violent felons into the community in the interest of being effectively sanctuary cities. But you need to consider the bigger picture and the bigger question, which is why? Why would elected law enforcement officials defy a federal law enforcement agency and release violent felons into the community? The flippant answer, of course, is job security. But even a perennial cynic like me acknowledges there has to be more to it than that. We need to consider the commonality of leftist positions on each and every political issue of our time, namely that they are self-destructive. Destructive not only to conservatives, but to the leftists themselves, because after all, they have children and families too, families that will suffer if they ultimately prevail in the political debate. Think about it. Each of those issues under debate. Open borders. The left is all for environmentalism and supposedly saving our natural resources, except when it comes to opening the border to let millions of less than environmentally conscious illegal aliens overrun that natural landscape. Homelessness. I actually had a San Francisco leftist troll tell me earlier this year that she lived in a progressive paradise. Really? Is it a paradise when homeless encampments overrun the city, resulting in widespread trash and even defecation in the streets and the resurgence of long-eradicated diseases like typhus? Because after all, that is what homeless policies in places like San Francisco do. How about the Green New Deal? Do you think the destruction of modes of transportation and sources of energy will impact only conservatives? Or how about the universal health care? The dirty little secret of the healthcare debate is that modern medicine is expensive and that it is utterly impossible to provide it to every man, woman, and child. So if the left gets its way and we enact socialized medicine, resulting in the rationing of medical care and massive delays in critical medical procedures, just like Britain, do you think the left won't feel the impact personally? Then we have gun control. We've seen the explosion of violent crime in gun control utopias like Venezuela, Brazil, and even the UK. And I grant you that some limousine liberals live in gated communities and have armed guards. But if they manage their goal of banning the private ownership of firearms with the inevitable explosion of violent crime, don't you think the left will be victimized as well? Or last, but by no means least, my personal favorite, the left's charming habit of branding those of us who correctly identify the barbarism of Sharia law and Islamism that we are Islamophobic. Has it not dawned on feminists that women are being stoned to death as adulteresses or murdered in honor killings? Has it not dawned on the alphabet people, the LGBTQ and whatever other letters they've added this week, that the Islamists are the ones throwing gays off buildings? Maybe it has, at least to some. Now, I've long said that the left can be broken down into essentially 2 predominant groups, the stupid but well-intentioned and the manipulators of the stupid but well-intentioned. That left-leaning cousin of yours might be the former, but I can assure you that Adam Schiff is the latter. But as stupid as I consider most of the left to be, even I don't think they are so stupid as to be utterly unaware that the nightmarish policies they propose will hurt them too. Now, throw in the extreme leftward lurch that began in earnest with the election of George W. Bush in 2000 and accelerated dramatically with the election of Donald Trump in 2016. In 2000, gun control advocates were talking about sensible gun safety laws. Now they're talking about repealing the Second Amendment and banning the private ownership of firearms. In the 1990s, even liberal Democrats supported some level of border controls. Now we have Democrat presidential candidates who are not only talking about not building new border walls, they want to tear down the ones we already have. Hell, even the Washington Post admits it. 2 weeks ago, the Post ran a piece entitled, "The Democrats are Moving Left. Will America Follow?" Said the Post, and I quote, "Perhaps the great unknown of 2020 is how the tenor of the Democratic nomination contest will affect the general election. The outcome of the primaries and caucuses, of course, is far from clear. But what is clear is that the party has shifted in fundamental ways since the last presidential election. You could see it in the policy positions being discussed and embraced by Democrats, many of which go well beyond the positions taken by previous Democratic presidents and nominees, from banning private insurance to free college to a wealth tax to the Green New Deal. You could see it in the left populist worldviews and solid poll numbers of two of the three leading candidates, Senators Elizabeth Warren and Bernie Sanders. And you could see it in the substantial popularity among the Democratic rank and file of Representative Alexandria Ocasio-Cortez and her allies in Congress. Indeed, the Democrat Party has moved radically towards socialism and its kissing cousin communism, of course, so much that it has left Joe Biden and even one of its principal architects, Barack Obama, behind. But the Washington Post stops short of the critical question, a question it likely doesn't want to answer. Why? The left would blame Donald Trump, of course, as they blame him for everything else, and to be fair, they aren't entirely wrong. The foaming-at-the-mouth Trump haters certainly got the ball rolling as early as Inauguration Day. I mean, you remember Madonna, who thought an awful lot about blowing up the White House, or the MSNBC news anchors who actually cried when they reported the election results? The Trump haters normalized extremist speech from the left. I mean, as soon as the celebrities started saying radical things, it was obviously okay for everybody else on the left to say the same radical things. But what we need to realize is that they didn't just start saying any old thing. No, Trump was the catalyst that got the left saying what they really mean, saying, in fact, what they really intended all along. Not just to the left's takeover. I mean, we can attribute this not just to the left's takeover of the Democratic Party at the 1968 Democratic National Convention, not just to the 1967 Summer of Love, no, probably back to the 1950s and beyond. Donald Trump is just the catalyst for the authoritarian collectivism that the left has always wanted but could never say. And in fact, you can thank Donald Trump for bringing the American political debate into stark relief so you can hear what the left actually has in mind for you, their authoritarian collectivist worldview. In fact, Barack Obama had a rare moment of truth a couple of weeks ago when he warned the left to cool it, saying, and I quote, "Even as we push the envelope and we are bold in our vision, we have to be rooted in reality. The average American doesn't think we have to completely tear down the system and remake it." What he meant is that the average American doesn't think we have to completely tear down the system yet. But make no mistake, tearing down the system is exactly what it's all about. It is exactly what the left has always been about. Because what you must always remember is that only by tearing down the system can they rebuild it as the socialist utopia they envision. My name is Paul Vlone. You've been listening to Guns, Politics, and Freedom on Wilmington's Big Talker, 106.7, WilmingtonBigTalker.com, where each Sunday at 5 p.m. we give you the ammunition to better defend your gun rights. I also encourage you to check out my website at gunspoliticsandfreedom.com, spell out that and, gunspoliticsandfreedom.com, where you can find both my writings and earlier editions of the show. See you next Sunday at 5.